Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come today to court for arraignment. Arraignment basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have in this court is a misdemeanor. If you had a felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If a person is convicted of a second-degree felony, the range of punishment is a minimum of 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment minimum is 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. If a person is convicted of a capital murder, the range of punishment minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, you have a misdemeanor case, so you don't have to worry about those punishments. Now, misdemeanors are divided into 3 categories. So we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only, and the fine cannot exceed $500. Now, if a person failed to pay the fine, or if fine was converted to community service and the community service was not completed, then the court can issue what is called a capias pro fine, which means it's a warrant for the person to sit out the time in jail for the fine. Now, a person will be credited at $100 per day for every day that he sit out in jail for the fine. The next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor, if a person is convicted, is minimum 0 days to a maximum of 180 days or 6 months in the county jail, a fine from $0 and does not exceed $2,000. Or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, which is 1 year, a fine from $0 up to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. And one of the rights, at least the first right that we're going to go over, is your right to have an attorney. And that information is on the clipboard that has been handed out to you. The first document on the clipboard should be Judge's Explanation of Rights to Defendants Without Attorney. And it basically says that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Number 3, you may represent yourself if you waive or give up your right to hire an attorney. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date so that you will have enough time to hire your attorney. If you want to hire an attorney, well, if you want an attorney, but you do not have enough money to hire an attorney, you will have to fill out a financial questionnaire. The financial questionnaire is the document on the clipboard that is titled Jefferson County Affidavit of Indigence. You would have to fill out the first page of that document and half of the second page of that document. Once you fill that document out, then the proper person will determine whether or not you qualify for the appointment of a court-appointed attorney. If you want to waive your right to have an attorney or give up your right to have an attorney and you want to represent yourself, then you will be allowed to talk to the prosecutor. The prosecutor is a young lady that's sitting at the table before you. She is an assistant district attorney that works in the Jefferson County District Attorney's Office. You'll be able to talk to her to see if you can settle your case. When I use the term settle, what I mean by that is you will be able to talk to her to see if y'all can work out a plea bargain. A plea bargain is an agreement between you and the district attorney's office to settle your case. Now, you cannot talk to her unless you first sign a written waiver of your right to have an attorney. The written waiver is the second document on the clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You'd have to read and sign that document before you are able to talk to the prosecutor about your case. And I'm going to go over that document with you in a few minutes. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that first document, that's titled Judge's Explanation of Rights of Defendants Without an Attorney, it states in bold letters, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left of that document. If your choice is, well, if you have already hired an attorney to represent you, then you will place your initials on the second line of that document, and you will place the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to have an attorney and to represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled Defendant. And you will date it to today's date, April 2nd of 2024. Now, for those of you who will be waiving your right to have an attorney to represent you, and you will be representing yourself, you would have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised the second day of April of 2024 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, April 2nd of 2024. As a defendant in a criminal case, you also have a right to have a trial by jury. That area over there with those 12 chairs, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence and the arguments. They will deliberate, and then they will decide whether to find you not guilty or guilty. You have a right to waive or give up your right to have a trial by jury. And if you waive or give up your right to have a trial by jury, you will not be having a trial by jury. However, your case will come before the court in one of 3 ways. One way it will come before the court is by way of a bench trial. A bench trial is a trial by judge only. You don't have a jury, you just have a judge. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence. The judge will listen to all of the arguments, and then the judge will decide, based on the evidence and the law, to find you not guilty or guilty. Another way that your case can come before the judge is by way of a plea bargain. It's by way of an agreed plea bargain. An agreed plea bargain basically means you and the state have been able to reach an agreement, and you want the court to follow your plea bargain agreement. And if the case comes before the judge by way of a plea bargain agreement, the judge can do one of 2 things. The judge can either accept or reject your plea bargain agreement. If the judge rejects your plea bargain agreement, then you will be entitled to withdraw, which means to take back your plea that you have entered into with the state. For example, let's say you and the state have worked out a plea bargain agreement and the state has agreed to give you probation in the case. And the judge says, well, I'm not going to follow that plea bargain agreement. You say, well, judge, I withdraw or I take back my plea bargain agreement. You have a right to do that. Now, if the judge does follow the plea bargain agreement and you decide within 30 days that you would like to file a motion for new trial, you would have to get permission from the court to file the motion for new trial. Or if you would like to appeal, you have to get permission from the court to appeal your case or file a motion for new trial. Now, if the judge gives you permission to file an appeal, then the case will go to the Ninth Court of Appeals. It leave this court and go to another court, which is Ninth Court of Appeals, located right above us on the 3rd floor. It's called the Ninth Court of Appeals. They will review your case. They can either accept, or that is, they can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, or they can send the case back down to this court and order this case to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. They are located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se petition basically means, pro se means on your own. You will be representing yourself. You will not have the assistance of an attorney, and you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, or whether or not this court committed an error by convicting you. If the Court of Appeals, the Court of Criminal Appeals can do one or two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can just send the case. They can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send the case back to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court to testify. Witnesses testify, they'll sit in that chair that has the microphone in front of it. That's called the witness stand. They can testify for you or against you. If you're representing yourself, you can ask them questions. If you have an attorney representing you, your attorney could ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. That simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. If the state call witnesses, as I mentioned earlier, you have a right to ask them questions. We call that either direct examination or cross-examination. You also have a Fifth Amendment right against self-incrimination. What that means, you have a right not to testify in your case. The state of Texas, the district attorney, or the government cannot force you to testify against yourself in your case. If you waive or give up your right to have, if you can waive or give up your Fifth Amendment right against self-incrimination, and if you do so, you will be testifying in your case. You also have a right to have discovery. Discovery is you have a right to see the evidence that the state has against you. You have a right to see the witness statements, your statement. You have a right to see police reports, lab reports. You have a right to see video recordings, listen to audio recordings. You have a right to also see any instruments, documents that the state will be using against you in your case. Or you have a right to waive or give up your right to have discovery, and by doing so, you will not be having access to the evidence that the state will be using in your case. Now, as a defendant in a criminal case, everyone here has been arrested. You've been arrested on your case, and you're out of jail on bond. And since you're out on bond, you're either out on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you're out of jail on a PR bond or a personal recognizance bond, which means you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Now, any time that you spent in jail, whether it be 1 minute or more, can be used as credit towards your punishment. For example, so 1 minute is considered 1 day. So if you booked in, booked out, that's considered 1 day. So every day that you spent in jail can be used as credit towards your fine and court costs. So for example, let's say you're in the state, worked out a plea bargain agreement, you spent 5 days in jail, and the state worked out a plea bargain agreement for you to serve 5 days in jail. That simply means you would not have to serve any more time in jail, because you'll be given credit for the time that you've already served. So therefore, you'll be given credit for time served. Now, If you spent 5 days in jail and the state is offering 7 days in jail, we will simply subtract 5 from the 7, and it leaves 2 days. So you'd have to serve 2 days in jail. Also, every day that you spent in jail can be used as credit towards your fine and court costs. You receive credit of $100 per day that will go toward your fine and court costs. So, for example, if the state is offering you fine and court costs of $500, you spent 5 days in jail, that's $500. Then you will not have to pay anything because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Now, if the state is offering fine and court costs of $700 and you spent 5 days in jail, which is $500, we subtract 500 from the 700, that leaves $200. And that means that you would have to pay $200 toward your fine and court costs. Now, you're required to pay it on the day that you enter your plea. However, if you cannot pay the $200, then we can put you on a payment plan. You can pay it off in monthly installments until the balance is paid off. Now, if you are unable to pay off the $200, then we can convert the $200 fine and court costs to community service. You will receive $12.50 for every hour of community service that you perform. So, for example, if you perform 8 hours of community service, that's $100. So in the scenario that I just gave, which means that you are balanced at $200, you work 16 hours, which is 2 days, that's $200. And the fine and court costs of $200 balance will be paid off. Now, Jefferson County has a program that is called pretrial diversion. If you've never been in trouble before, well, Jefferson County has a program that will dismiss your case. In order to qualify for the program that is called pretrial diversion, you have to have an attorney to assist you at getting into the program. It has to be your first time getting into trouble, and it cannot be for an offense involving resisting arrest or unlawfully carrying a weapon. Now, if you do qualify, the case will be dismissed, and if you successfully complete the program once you're in it, then you can get the case expunged, which means erased, deleted, or wiped off from your criminal record. It's like it never happened, okay? That's called pretrial diversion for first-time offenders. If you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. It's for veterans only. It is also part of the pretrial diversion program. Once you enter into the Veterans Court program and complete the Veterans Court program, your case will be dismissed. It will not result as a conviction on your record, and you may qualify for what is called a non-disclosure. A non-disclosure is basically a sealing your record to the general public. So the general public cannot have access to it. However, the government can have access to it. So most of the public is the general public, so they cannot have access to your record if you get a non-disclosure. Jefferson County has a program that is called, well, Jefferson County Court at Law Number 2, this court, has a program that is called the CSI program. That is a program that I started within 100 days of taking office in March of 2017. With that program, we have partnerships with our local agents, and the program is designed to address the issue of what we call recidivism. Recidivism means when people commit crimes over and over. And so how do we address it? Well, we address it through our CSI program and the Community Safety Initiative. We have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center. Spindletop have the ability to address your mental health needs. With Spindletop, they'll be talking to you in a few minutes and tell you more about the programs that Spindletop has to offer. But basically, with our program, Spindletop can do a private interview. They can they can have an assessment, develop a treatment plan for either outpatient, inpatient, depending on what your needs are, to address your mental health needs. Now, you could just merely suffer from anxiety, depression. You do not have to be incompetent and insane to participate in the program. If you have problems or issues with drug or alcohol dependency, well, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. Our local Drug and Alcohol Council of Southeast Texas has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And basically what they'll do, they can do a screening, an assessment, and also they can refer you for either outpatient or inpatient treatment, depending on your drug or alcohol dependency needs. If you are unemployed and do not have a job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're training in one of those areas, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you do not have a high school diploma, CICE program has a GED program where you get your graduate equivalency diploma. All of these programs that I just mentioned are free. It does not cost you anything but time. And in this court, I like to say we do not just give time, we take out time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And we believe that if we produce productive people will not commit crimes because they have too much to lose. And so when you come to county court at law number 2, we don't have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives, the individuals that comes before this court. And if we make a difference in their lives, then we will make a difference in their home. And if we make a difference in their home, then we will make a difference in the community, because what comes out of the home goes into the community. So all of these programs that I just mentioned to you are free. And the other benefit of these programs is that all of these programs can be used as community service towards your punishment. So for example, let's say you are ordered to pay a fine and court costs, but you cannot pay it because you do not have the income, and the court converted your fine and court costs to community service. For every 1 hour that you perform in the Spindletop program, or in the ATAR or the OZAR program, or in the CICE program for job training and job placement, or even if you're in class working on the GD, for every 1 hour in any one of those programs, $12.50 will go toward payment of your fine. 1 hour will go toward the community service. And then the other part is you'll be participating in the program. So you'll be doing one thing, but you're getting credit for two things. One, you're getting credit for the program. 2, for the community service. And 3, you're getting credit for the payment of your fine and court costs. So if you're interested in any one of these programs, just let us know, and we'll be happy to give you the information that you will need to participate in any of these programs that I've just mentioned. Now, at this time, we have Chris and Deputy Hinton. They're with Spindletop. They're going to come to you and tell you a little bit more about the program that Spindletop has to offer. Deputy Hinton and Chris.
Thank you, John.
Welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's office. I'm here with my coworker, Chris. Now, Chris is a qualified mental health professional. The reason we are both here this morning in this courtroom, the judge cares about every single person that comes before the bench. What the judge has found, what statistics prove, is those who have legal issues currently have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in a particular situation.
So, as the judge said, a lot of times this looks like anxiety, depression. This is something that everyone goes through at some point in their lives, and that being involved in the court system does not necessarily make it easier. Sometimes it actually costs. Like the judge said, there's a lot of really great community resources, but inpatient and outpatient, we cannot send anybody to any resources. We can provide information if you need specific information on those resources. Now, like I said, a lot of really great community resources, they are well funded, they're not well advertised. Sometimes even just finding them can be a bit like jumping through. And that's where we come in.
So maybe this is your first time to be in court, maybe it's your 10th time to be in court, there's still hope. In fact, what we're offering you has the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us so we can best see how to advocate for you. And Chris is gonna explain how you can do that very privately.
Ms. Mosby.
So, when everybody came in, you were all handed this form, right? It was handed to both. Everybody was handed this form. It was handed to both support defendants because we acted the job before. I recognize that. It does not matter if you're here for yourself or you're here for somebody else. It doesn't matter if you need information for yourself or somebody else. All that matters is we have this moment, we can use it. This is not a place anybody wants to be, right? But I'm sure there's plenty of names that were called outside that didn't come in. You guys all showed up. We know you work hard for yourselves. We know that you care about yourselves. That's what we're here for. We care about you too. The only thing on this form that you can, so this is built like a baseline HIPAA consent form, right? The reason it's built this way is so that you know that any information on it is protected under state law, the same as your medical information. The only thing you're consenting to on there is me contacting you once in a manner of choosing and continuing to talk with you if you want to talk with me. If you continue to reach back out to me, then I will promise I'll work as hard for you as you do for yourself. The big thing is that we know there's a lot of research needs, and sometimes the biggest need is support. We know there's a lot of stuff that people go through in life, and a lot of we don't get a lot of help for. This should not be the first time that we get help. But we're here. So with that, there's options on there for call or text. Some of the forms have email. I apologize, we ran out of the newest version of the form. If you have specific resource needs that doesn't have the check boxes on there, please put them down. And I promise I'll do my best to find them. It doesn't matter if you're from here in Jefferson County. It doesn't matter if you're from Texas. If you have something you need, we will do our best to help. There's also the option of sticking it at the bottom. What that means is just you can write with me in the back if there is time for it. If you are not comfortable talking in the courthouse, that is okay. You can put down time you want to call. This is meant to be something easy that works within those letters. You know, there's a lot of other stuff that you're probably managing that you're juggling at the same time. We're not trying to add anything from that, and I understand that sometimes it can feel like it adds to it. All we're trying to do is help take some out of it. So if you tell us when is the best time to reach out to you, or what you need, I will do my best to match it.
I also have a flyer here that I want to use in everyone's hands before you leave here today. On the back, it tells you some of the advantages of actually participating. And on the front, it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help you.
So one of the big things about that flyer, that 1-800 number, there is a crisis one and a toll-free number. Both of those are active almost statewide. As I said, it doesn't matter if you are from this area, because we don't have people who come to court in Jefferson County, but not from anywhere close to here, right? So that number is, again, active almost statewide. I say that because we know Texas has way too many dead zones. But outside of that, it's 24/7. It's the first resource we can give you. You can call them at 6 a.m. on Christmas morning, and they will be there. Now, if you have something you need that's not crisis, please talk to me first, because we can do our best to help you find it and get something set up and just be there with you through it.
Just shortly, the court is going to go into recess, and when it does, we'll be free to come out there. We'll visit with you. We'll pick up those documents from you, and I'll be handing this out to you as well. We'll be able to answer any question you have at that time.
Okay.
Thank you, Your Honor.
You're welcome, Deputy Hinton. Yes. Now, ladies and gentlemen, in a few minutes, we're gonna go into recess. But before we go into recess, I need to give you some instructions. The information that you have on the clipboards, if you need help with that information, we have our core personnel who's here, will be happy to help you with filling out the information that's needed on the clipboard. If you need to use the restroom, there are two restrooms right outside in the hall. The male restroom is in front of County Court at Law Number 3, and the female restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you can go out into the hall. If you need to use one of those restrooms, you can. Do not leave the courthouse. If you leave the courthouse and your name is called, then your bond will be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. So you can go out into the hall, but then do not leave the courthouse because we're not finished. We're just about finished. And then once we finish, we're picking all of the clipboards up. We're gonna call you up one at a time before the bench. And once you finish here, you'll go to our court coordinator to give you your paperwork, and then you'll be able to leave. So at this time, we're going into recess. If you need any help with filling out the paperwork, please raise your hand. Jefferson County Court at Law number 2 is back in session. Court is in session with the arraignment docket. First case is cause number 23CCCR 0596. Case is style of state of Texas versus Jace Gabriel Woods. Mr. Woods, your full name is Jace Gabriel Woods?
Yes, sir.
Yeah, don't lean on that, the table.
Sorry,
Mr. Woods, how are you doing?
I'm good.
That's good. Mr. Woods, you're representing your case by your attorney, Attorney Philip Dowden. Attorney Dowden, how are you doing?
I'm great, Judge. Thank you, President.
You're welcome. State is representing this case by Attorney Erica Porter. Attorney Porter, how are you doing?
I'm doing great, and how about yourself?
I'm doing fine. Ms. Porter, I have a motion to dismiss this case. Is that correct?
It's correct, yeah.
Okay. Mr. Woods, I'm signing this motion to dismiss this case. The attorney will be given a copy in a few seconds. Once you get a copy of this motion from your attorney, well, once you get a copy of the dismissal, you'll be free to go. And you have a blessed day. And Mr. Dowden, you'll be free to go as well.
Thank you, Judge.
Please stand in front of the court partner. Did we check? Lisa Adams. Okay. Ms. Mosby. Court is back in section. Next case is cause number 23 CCCR 1258, case is style of state of Texas versus Chelsea Nicole Petaway. Your full name is Chelsea Nicole Petaway.
Sir.
You may put your hand up. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Oh, you may put your hand down. How are you doing? That's good. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Sir.
Now, on this, you put your initials online and state that you have hired an attorney whose name is Rife Kimmler. Is that correct?
Yes, sir.
Now, your case is going to be reset. Please, please have a seat in that first chair by the wall, and once she calls your name up to the window, you go to the window, get your reset, you're free to go, and you have a blessed day.
Thank you, you too.
You're welcome. Next case is cause number 23 CCCR 1322, case of style of state of Texas versus Jeremy Jamal Mars. Okay, Mr. Morris, your full name is Jeremy Jamal Mars.
Yes, sir.
Mr. Morris, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing? You doing all right? That's good. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature online inside of defendant?
Yes, sir.
Or are these your initials online? State you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign and initial this document, did you read the document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Hey, Mr. Morris, you can have a seat in that third chair on the wall. And when your name is called, you go to the window to the coordinator and she'll reset your case and you'll be free to go and get a blessed day. All right, thank you. Okay, he's representing. Next case is cause number 24 CCCR 0170, case of style of state of Texas versus Keithia Moulton. Ms. Moulton, you can put your purse on that table. Ms. Moulton, your full name is Keithia Moulton.
Good morning. Yes, sir.
How are you doing, Ms. Moulton?
I'm good at yourself.
I'm doing fine, thanks for asking. Ms. Moulton, would you please raise your right hand?
Mm-hmm.
You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
You may put your hand down. Ms. Moulton, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah, I signed up in here.
Yeah,
Yes, sir.
is this your signature on this document?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document before me that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Mm-hmm.
On page 2 of this document, there is a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Ms. Moulton,
Mm-hmm.
before you sign and initialed all of these documents that I just showed you,
Yes, sir.
did you read the documents?
Yes, sir.
Did you understand what you read?
She read it to me.
Okay, so someone helped you to fill out these
Yes, sir.
documents?
Because I'm a partial lawyer.
Okay, is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Ms. Moulton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will also be given information to contact him. The court coordinator is going to give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please, yes,
I go to the hospital on the 11th for surgery. So
you can tell her, you can tell, the court coordinator, she could reset it on a date that you will not be in the hospital.
Okay.
Okay, so just, you're gonna have a seat in that first chair by the wall. The first chair by the wall.
Thank you.
You're welcome.
This one.
Okay, it's gonna be in June. Okay, yeah, we could just have.
Next case is cause number 24CCCR 0186. Case is style of State of Texas versus Damian Knighton Jr. Mr. Knighton, your full name is Damian Knighton Jr. Knighton, would you please raise your right hand? Mr. Knighton, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Knighton, you may put your hand down. How are you doing, Mr. Knighton? That's good. Mr. Knighton, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that is titled Defendant? Or are these your initials on the line that states you would like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Knight, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Knighton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Joel Vasquez.
Yes.
Joel Vasquez will be given information to contact you. And you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Now, Mr. Knight, before she gives you that information, I need the bailiff is going to hand you a document that is titled Standard Bond Conditions. I need to go over these bond conditions with you. Standard Bond Conditions in County Court at Law, number 2. Mr. Knight, the document that has just been handed to you is titled Standard Bond Conditions in County Court at Law, number 2. Do you see that type? I'm going to read these I'm going to go over this document with you. And the document reads as following: following the return of permanent information in County Court at Law number 2 of Jefferson County, Texas, All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court. Ma'am, that door is closed. Or B, submits to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 and 4 does not apply. However, condition number 5 does apply on the second page. And it reads as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that? Do you understand that condition? Now, Mr. Knighton, Mr. Knighton, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay. Now you can have a seat in that first chair up on the wall and wait for your name to be called. Next case is cause number 24-CCCR-0294. Case is style of State of Texas versus Jose Enrique Valencia. Mr. Valencia, your full name is Jose Enrique Valencia.
Yes, sir.
Mr. Valencia, would you please raise your right hand? Mr. Valencia, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Valencia?
No problem, but you see this.
I'm doing fine. Thanks for asking. Mr. Valencia, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature online as title defendant?
Yes, sir.
And are these your initials online state you'd like to apply for a court-appointed
Yes,
attorney?
sir.
I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature on the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Valencia, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Valencia, I've read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our coordinator will give you that information, but before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions. I'm going to go over this document with you. Mr. Valencia, did you see the title Standard Bond Conditions in County Court at Law number 2?
Yes, sir.
And I'm going to go over this document with you. And it reads as follows: following the return of the criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition 3 and 4 does not apply. However, on page 2, condition number 5 does apply and it reads as follows. Defendant is prohibited from possessing a firearm ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Valencia, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Now, Mr. Valencia, our court coordinator is going to reset your case. Once she resets your case, you'll be free to go and you have a blessed day. Please have a seat in that first chair by the wall.
Thank you so much.
You're welcome. Ryan Christopher Pearson. Mr. Pearson, your full name is Ryan Christopher Pearson. Mr. Pearson, would you please raise your right hand? Mr. Pearson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Pearson, you may put your hand down. How are you doing, Mr. Pearson?
Pretty good.
I'm doing fine, thanks for asking, Mr. Pearson. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes.
Mr. Pearson, I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Mr. Pearson, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents correct to the best of your knowledge?
Yes.
Mr. Pearson, I read your answers. Mr. Pearson, a prosecutor is going to come out and talk to you in a few minutes. You can go back and have a seat. Pearson. Miss Jack, oops, what was that?
Well, he didn't tell me he wanted to hire somebody, he just said he wanted to decide which offer he's gonna accept.
Oh, okay, so, we're just gonna reset your case
Yeah.
to give you time so you can make up your mind?
Communicate with my family.
That's fine.
Let them know what.
Okay, let's, reset this case. Let's give them a standard reset. Once your case is reset, you'll be, free to go. I guess we're gonna put him back on,
You want?
no, don't put him on the regular, just put him
Put
on.
him on the announcement.
Yeah, okay. Now, the next docket you come is what we call an announcement docket, okay? So, you stand in front of the court coordinator, get your reset. Once you get your reset, you're free to go and you have a blessed day. And this is cause number 24 CCCR 0188, case of style of state of Texas versus Mariela Rodriguez. Ms. Rodriguez speaks Spanish. We have Ms. Jennifer Rod, who is our Spanish translator. Ms. Rodriguez, please raise your right hand. You swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
Okay. Ask Ms. Mariela Rodriguez if her name is Mariela Rodriguez.
Yes.
Okay. Ask her to raise her right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may put your hand down. How are you doing, Ms. Rodriguez?
Good.
Good? That's good. Now, Ms. Rodriguez, I have before me a document. It is in English and it's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
And are these your initials online that state you want to apply for court-appointed attorney?
Yes.
And I also have a document. This document is Jefferson County Indigency. Do you recognize this document? And this document is in Spanish. And is this your signature on the line that's titled defendant signature?
Yes.
Now, Ms. Rodriguez, before you signed and initialed these documents, did someone explain these documents to you in Spanish?
Yes.
And did you understand, and Ms. Araji explained these documents to you in Spanish, is that correct?
Yes.
And before you signed and initialed these documents, is everything in these documents, did you understand everything that Ms. Araji went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Okay, Ms. Rodriguez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Charles Rojas. He speaks Spanish. Now, Ms. Rodriguez, please have a seat in that first chair, and then when they're ready for you, you're gonna get your reset and you'll be free to go.
Okay, gracias.
You're welcome. I think Here, Mr. Littleton. This is cause number M 333-440, case of style of state of Texas versus Max Owen Littleton. And Mr. Littleton, is that your full name?
Yes.
Okay, Mr. Litt,
Lincoln the third.
okay. How are you doing, Mr. Littleton?
I'm doing fine, thank you, and you?
I'm doing fine, thanks for asking. Mr. Littleton, your case is being reset with your felony case. And that case is being reset till, well, this case is being reset till June 24 to 2024. Our court coordinator will give you your reset. Once you get your reset from the court coordinator, you're free to go. And you have a blessed day. Stay in contact with your attorney and your boss. Same to you. Okay. Your full name is Jorge Lopez. Okay, Mr. Lopez speaks Spanish. We have our interpreter, Mr. Raji. She's already been sworn in. Mr. Lopez, would you please raise your right hand? Mr. Lopez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, so you must speak some English. A little bit? Okay. Now, Mr. Lopez, you can put your hand down. How are you doing, Mr. Lopez? You doing good? Mr. Lopez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize, ask Mr. Lopez if he recognizes this document.
Yes.
And is this your signature on the line that's titled defendant? Action.
Yes, it's completo. Yes.
Are these your initials stating that you'd like to apply for court-appointed attorney?
Y esas sus iniciales que querías aplicar para un abogado. Yes.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
Now, this document is in Spanish. On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Mr. Lopez, before you signed and initialed these documents, did Mr. Raji go over these documents with you in Spanish? And did you understand everything that she went over? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Okay. Mr. Lopez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. An attorney that will be appointed to represent you is Charles Rojas. Mr. Lopez is gonna be, Mr. Lopez, Mr. Rojas will be given information to contact you, and you will be given information to contact him. And our court coordinator is going to give you that information. Before she gives you that information, I need to give you a document that is titled Stand Bond Conditions in County Code at Law number 2. I'm going to go over these bond conditions with you. And it reads, standard bond conditions in County Code at Law number 2. Following return of a criminal information, County Code at Law number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court. Or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Condition number 3 and number 4 does not apply. However, condition number 5 on page 2 does apply. And condition number 5 states as follows. The defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Penal Code. Actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Mr. Lopez, do you understand this condition? Now, Mr. Lopez, if you violate any one of these conditions, your bond will be revoked and a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes.
Okay. Now, Mr. Lopez, this will conclude your case for the day. You're gonna have a seat in that first chair by the wall. And when your name is called, you're gonna go to the court coordinator's window. And she'll give you your paperwork. Once you get your paperwork, you're free to go and you have a blessed day. Thank you, Mr. Ryder.
Yes, sir.
Here you go. Okay. Dwayne Hale. He went to felony court. Ryan Matuska was his attorney.
Who?
Ryan Matuska, Dwayne Hale.
Isn't he in jail?
Oh, he is? Okay. Okay,
Okay, Mr. President. Oh, Kingston, this anywhere? Okay, it's.
Lakey was reset.
1519. 6-3, you got me 280.
It was 639.
Yeah, okay, yeah, 1519.
Oh,
Thank you.
Valdez never came.
okay, next, let's see.
Who?
Hold on, Elsie's in jail.
Valdez was reset, so.
Well, I hadn't got there yet.
Oh, he never came in. Yes, he was with the.
On your local court.
Charles Adams, page 5.
That's the one that.
Okay, transfer.
I'll talk to you outside.
Okay. Charles Adams on page 5.
That Barker person. Yeah, Barker.
Jameson Lewis Barker. Would you?
Thank you, Jim.
Jefferson County Court, Law number 2 is back in session. Court is in session with the Raymond docket. Next case is cause number 24CCCR 0176. Case is South of State of Texas versus Jameson Lewis Barker. Jameson Barker was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., Jameson Barker's name was called at the courthouse door. Jameson Barker did not answer. The time now is 11:53 a.m. on today's date of April 2nd of 2024. Ms. Bailey, would you please call the name of Jameson Lewis Barker at the courthouse door?
Jameson Barker. Jameson Barker. No response, Your Honor.
Jameson Barker's name was just called again at the courthouse door. Jameson Barker did not answer. A reasonable time has passed to give Mr. Barker an opportunity to appear in court. State, do you have a motion?
Statement from bond forfeiture.
That motion will be granted. Jameson Barker's bond will be forfeited and a warrant shall be issued for his arrest in cause number 24CCCR 0176. Uh, and this will conclude the calling of the court's arraignment docket on today's date of March, let's go on the 8th, on the day's date of April 2nd, 2024. In County Court at Law Number 2, Jefferson County, Texas, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.